here.
Is sound okay? Please confirm that you hear me.
I can hear you. Yes.
Thanks. Okay. So today we believe that in our world, highly disproportionate system of criminal justice spoils the life of millions of poor people and create total inequality for these people in the principle of the access to the equal justice. And we will today explain first why we believe that state lawyers, who now will be the only option for all those people, create symmetry in and access to equal justice, and why this will make our world a bit fairer place. First, about the model. We believe that that the current problem of state-employed lawyers who are not always highly qualified will be resolved in our world by several things. First, now as government is in full control of these lawyers and in full responsibility of these lawyers, it will perform regular checks of their proficiency, meaning that we will not accept any kind of lawyers who are not proficient enough to be able to represent defendants in the court. Second, we believe that as government now is responsible for the quality of the help provided, it will have an incentive to improve the quality of knowledge and skills of these lawyers, meaning that it will provide special courses, it will have some free or accessible university degrees, it will provide any qualification help for these lawyers. Also, we believe that some people who are currently working in criminal justice sphere will also now go to the state employed version of this because just they like this sphere of the justice. And also we believe that state employed lawyers will now get more money because now currently their salaries are not that high due to the reason that they are predominantly protect poor people who have no option to pay for them, and government does not pay them much due to the reason that we have private practice. Now, when there is no private practice and a lot of lawyers will be hired by the government and they will be involved in much more cases than they are currently involved in, meaning that they will have more premiums for the victories in their case, meaning that their salaries is now increases, meaning that they have higher incentives to show qualified results. Also, to avoid any unexperienced lawyer in a severe case, we will distribute these lawyers depending on the case severity and matching their experience, meaning that we will have symmetry, and if the case is really severe, we will have experienced criminal justice lawyer who will be able to represent the defendant. Why we believe that we have a right to do this? We believe that currently poor people who are first of all are poor just due to the lottery of their birth, just to the lottery of the circumstances that happened to be in such a way, are not able to protect themselves, and we as a government created by the people for the people have an obligation to protect those people. Also, we believe that a lot of crimes are committed due to some circumstances that do not depend on people. This can be poverty, this can be emotions, this can be some failure of the state itself, meaning that people as a whole have total right for equal justice. And we believe that this right for equal justice is higher than the right for the personal choice of private or state-employed lawyer in case of opposition may present. Why? Because today this choice, this is personal choice of individual exists only for rich people because they are the only ones who can pay a lot of money for good lawyer who is currently employed in a private sphere, meaning that poor people actually have no choice currently. And we believe that the number of those rich people are much less than of those who are who are poor, because even for middle class people it is very difficult to employ the lawyer because they cost a lot of money, meaning that if we cannot provide the personal choice of an individual to all people around the country. However, we can provide the right for equal justice to all of the people, because they will now be able to be represented by highly qualified lawyers without any asymmetry in it. We have to prioritize this principle over the personal choice of individual. We also believe that nothing changes actually for rich people, because they, as all the lawyers who are currently employed in this criminal justice sphere will go to the state employed version of it, they will still be able to get highly qualified jobs, meaning highly qualified help, meaning that they actually are not deprived of the help they were able to have previously, but now they will just not need to pay the money for it, meaning that we actually create more equality in our society and create more accessible justice for all the social classes that we have within the state. We also believe that this asymmetry in protection that we currently have is highly unacceptable in our society. What asymmetry we're talking about? The case is that rich people now have disproportionate amount of resources to be able to hire these lawyers, and poor people do not have. This means that if a poor person and a rich person commit the same level of a crime and get into the court, the rich person will get better help than the poor one. We believe that is not something that can be justified by anything in this world except for the lottery of birth, meaning that we have an obligation to change this asymmetry. As now, all the lawyers will be state employed and we will match them due to their experience and severity of the case. This means that both rich and poor will have an opportunity to be represented in an equal way, meaning that they will get the very same result for the symmetric cases, meaning that both rich and poor people will now have actually equal opportunity to be represented in courts. We believe this is highly important because as now poor people and middle class people cannot be protected, they are afraid of actually circulating in society. They cannot they are not sure in the government that protect them, and they do not believe in it as much as it could do. We also believe that nobody else except for the government can do this due to the several reasons. First, any privately any okay, thank you for time.
We thank the Prime Minister, and I'm happy to call upon the leader of the opposition. Prime Minister.
Okay, can you hear me?
Yes.
Thank you. Okay, what we speak to you today as a OG, we say to you that the poor people that we describe don't really have the individual right that the opposition proposes to you right now, because there is a disproportionate amount of power that rich people have in order for them to buy better lawyers, to find them which can really influence the way that the court exists right now, because they have more experience than those that are less priced lawyers, therefore they are more efficient in that course. Secondly is that they probably have better connections that they can use to influence the judges, the prosecutors, and so on, to get better prosecution. But thirdly, they probably have even more skills that can actually convince the juries that their defendant is not the one who has to be who has to go to the prison. So this is everything the poor people right now aren't getting, and we explain to you that we do not ever sometimes somehow miss those debates. We say to you that yes, there are two cases. First one is where the rich people now are accused and the regular people are actually getting are getting are prosecutors, like in some sort. So that means the rich people won't be able to hire the more educated lawyer, so he will have probably less educated lawyer, and so it will kind of make the just, because the other side of this, so the poor people, because the more oftentimes they often get or the state provided lawyer or the lower priced lawyer. That is to say, those lawyers will be the same, and therefore the court will be more just. But the second case is when the rich people will be the prosecutor and the poor people will be accused. So in this case, that accused person will get the higher educated lawyer that is not possible to get in a case of the when it is the status quo, because there is not a lot of the lawyers that can actually go to the governmental places, because the payment is not that good, or because the state doesn't actually care about this and don't really provide the better option for those people. So because we will now see that in those cases we have a poor people that probably doesn't have an amount of the resources that the other side can provide, therefore we'll give him a best lawyer that we could find, and therefore in those cases we also have the better justice. So some more responses to the opening opposition is that firstly they say that we have some discriminant lawyers that will discriminate our people, and so on, so on. So we understand that when we as a government now take more care about the lawyers and their reputation and what they do and their experience, because now we are more responsible because we are the main provider for the defendants, therefore we will have a lot more checks to pressure those people for them to not be discriminative. But secondly, this is possible also in their case, when the poor people that will go and buy the lower price lawyer, he can be discriminative as well. But the problem here is that the poor people cannot get the other lawyer because they don't have money for that, and therefore it is a monopoly for those kind of lawyers to actually to protect those people, so they can be discriminative as well. But secondly, on the case of the I won't believe my lawyer, we say to you that firstly, people still have a lot of the incentives to actually tell everything to their lawyers, because they understand if they won't actually tell all the details to their lawyers, they will go to jail, and therefore they will suffer a lot more. So we believe that this is a really strong incentive for the people to actually do this in the status quo. But secondly, because of the model that my teammate explained to you, this means the people will also be believing those kind of lawyers, because we will be as a government probably in some sort of marketing them or making them believe, and people will believe in those lawyers and us as a government, because they understand that we put a much more pressure towards those lawyers to actually be good ones and to do everything that that they can do. But so that's why we also believe that the incentives for the lawyers to be the best one are still exist, because firstly they still want to get the experience, they still want to get the fame and the recognition from them doing everything good in the case, because this is the social recognition, the social acceptance that they will get, and their acceptance as a specialist. So therefore they still have the incentives to show to those people that they're actually good ones, and to make them believe, and to use all the uh, all the psychological things that they can do to get into their beliefs. But secondly is that a lot of the specialists that weren't in the system of the governmental lawyers, they will get into the system right now, because they understand that there is a lot more possible for them to defend the people, not even more possible, but this is the only case where they can defend the people in matter of the defendants and not the prosecution. So that means, because a lot of the people want to pursue that kind of career, we will get those those good lawyers into that system, and therefore those lawyers that opposition explains to you that can be trusted, they still will be existing in our world as well, in this system as well. But what we say to you is that we get the thing that they don't get. It is the protection of the people who are not that protected right now, the poor people, the ones who cannot get the better lawyer and they lose it. It is really important because those people are suffering from that a lot more. This is the most important group in these debates because they cannot really actually get back from the jail if they are getting sued and got jailed unjustly because of the better lawyer that they have on their side. Because for now, if they they're losing their possibility to work on the job, to get better job, to educate and actually return to better life. Rich people are not suffering from that a lot more. They're suffering less from that because they have the resources, and therefore we believe that because of the disproportion that we have, the poor people have to be protected in the first place. Thank you.
We thank the Deputy Prime Minister, and I'm happy to call upon the Deputy Leader of the Opposition. Hear, hear. I thank the Deputy Leader of the Opposition, and happy to call upon the Member for the Government. Hear, hear.
I'm sorry if you called me, I might have missed it. Did you?
Yes, so Member for the Government.
Okay, can you hear me well?
Yep.
Just 1 second, if you please. Mr. Speaker, the opening government tells us that rich people have access to better counsel and because of that can get better outcomes in criminal proceedings. In the absence of sound principled argument of why that is important, or in the absence of actual harms, not lack of comparative advantage that the opening opposition points out, it is hard for the government to win. And these are the two things that we are going to bring to you in this debate. First of all, in regards to public defendant quality, we believe that the current situation leads to poorer public defendant quality than we would have in the status future. First of all, we realize that public defendants right now have to compete with private defendants that have a lot more resources. They have more time to spend on a case. They are also tend to be better paid and better quality lawyers. And that leads to the situation where judges and jurors are used to better performance from some stellar lawyers who who give very good speeches and very good quality argumentation. And that means that after they have heard from this private lawyer hired by a rich individual, when they hear a public defendant who didn't have as much time or who may not be as privileged, that means that the judges instinctively and without even realizing that compare this performance to the performance given by private lawyers, and that means that they judge the poorer defendants unfavorably because of the fact they have heard better lawyers before. And since poor defendants have do not have access to private counsel, that leads to bad outcomes for them, not just bad in the sense that they are worse than rich people can provide, but bad in the sense that they are worse than in a world where there would have been no private defenders. But also we believe that our policy will lead to better public defense in status future. Why is that? We believe that many lawyers will stay as public defendants and work for defenders and work for the government. Why? Because criminal law has its merits for the lawyers, because those are cases of life and death. Those are cases of major importance, and if you're a lawyer, you want to work with important cases because you feel that you are important as a person when you're working on them. Secondly, those are highly publicized cases. Those are cases of murder, cases that go on TV. And those two things mean that if you work in the criminal law system as a public defender, that leads to better opportunity for you for promotion to become a judge, for instance, in the British legal system. And that is something that lawyers covet. And we also believe that while being a public defender is not as lucrative as being a private defender, it is more stable because you get a flat rate, and you get this flat rate no matter whether you win or lose and so on. You get it for defending people, and that means that you can rely on that, and that stability is what leads to lawyers staying. And since all the lawyers that used to be, out of all the lawyers that used to be in the criminal law system, of course, some leave, but others who are very good lawyers and who are better lawyers than the average quality of public defenders in the status quo, they go on to become public defenders, and that raises the average quality of public defender, and that leads to better outcomes for those poor people. And of course, we believe that this is of primary importance because those poor people may have been trapped in poverty, they may have experienced racism or other forms of discrimination that led to them being the defendant. Maybe they committed their crimes because they were poor and saw no other alternative, or because they have been brought up in the situation where they were discriminated. And we believe that it is the rights of those people that we need to protect the most. But we also see other consequences of the status quo. A defendant is and if a defendant in a criminal case is in a dire situation, they face high stakes of punishment, of imprisonment. They are in an emotionally charged situation. They are in detention maybe. They have poor legal education and they can't choose a good lawyer. And that creates perfect conditions for exploitation by those private defenders. They can extort their potential clients for money, saying that they will get them off the hook. They will allow the defendant not to go to jail, and they can charge much more than it is reasonable to charge, leading those poor people to get into debt, to pay for their legal expenses, or to sell their assets, and so on. And we believe it is a bad consequence. And also we realize that an institution of contingency fees or success fees exist, where lawyers are paid more when they succeed in cases. And that leads to them not taking some of the cases where the probability of success is not high. And those cases also tend to be cases where defendants are from underprivileged or marginalized backgrounds, and where defendants have low probability of resocialization. And that means that those individuals need better protection, and it is them that should receive better protection. But if we only have private defenders, that probability is low, and with public defense system, it will be higher. And that is why we're proud to propose. Thank you.
I thank the member for the government, and I'm happy to call upon the member for the opposition. Hear, hear.
Is my voice clear?
Yes.
All right, 1 second, I'll just time myself.
Okay, so, I will be the member. I'm sorry for the confusion.
That's fine.
Okay. So at the beginning of my speech, I would like to make one thing very clear, that there is no doubt that the approach that the motion is taking will make the quality of the judging system a lot worse than it is right now. Because, like the opening government mentioned, state lawyers are not paid as much as private lawyers. Actually, they get a fraction of what private lawyers make. This forces those lawyers to take on way more cases than private lawyers do, which means less time and focus spent on each case. This makes the judging overall worse because each case is not giving the amount of time that it needs to actually to break it down and to get the good defense that the people deserve to get. One more thing is, yeah, I would like to give everyone a reality check. Lawyers who choose to work for the state are usually of less skill of private lawyers, because law school is very expensive. People want to find a job to pay their debt and to have the best quality of life. And no matter how good your incentive is going into law school, if you get a job that pays you way more than what state lawyers make, you will probably go ahead and take that job, which is being a private lawyer. It's like saying, let's force all doctors to work in a public sector, because if we have more doctors who provide cheap services to those who need it and are paid by the government, we'll get a better healthcare overall. Here, some people might get better healthcare compared with what they had, but most people will be left with doctors who have to treat double or triple the patients they used to treat before to get the same amount of money, which gives us a bad outcome overall. We'll see less focus on each case. So arguing that the judging system will become better is not valid. So let's talk about the lawyers themselves. The main difference between a state-employed lawyer and a private lawyer. First of all, who's paying them? Second of all, the ability to choose the lawyers for the criminal. And third of all, the ability for the lawyer to choose their cases. Now, those main three differences are our main attention, because although some lawyers choose to work for the state for a low salary and choose to give up choosing their cases, a lot of people who want to go into law school find these circumstances not aligned with their passion with becoming a lawyer, or why they wanted to go into law school in the first place. If a person is not willing to give up this privilege, they won't go and work as a state lawyer. They will simply not go into law school, because choosing to go to law school, if you're interested in criminology, and if you want to have the freedom of choosing your cases, is not on the table anymore. So whether someone is going into law school for the money or the cause, way less people will choose to go ahead and go and practice law. And by the way, if anyone has a POI, can you just open your mic, because I can't see the chat? Okay, so the second and third point, which was about the ability to choose the lawyer for the criminal and the ability for the lawyer to choose their cases. No, I'm sorry, and who's paying the lawyers. Those 2 points tackle a different stakeholder, which is the criminal themselves. Always, this presents a challenge for the motion, because one of the best things about private lawyers is being able to choose who will represent you and paying them to do so. Unlike state lawyers, who you cannot choose and are paid by the state to see if their approach and look on the case matches with what you have in mind, you're basically paying them the money that you cannot pay for the state lawyers. Yes, some people do not have that luxury of choosing their own lawyer and have to go with what the state gives them. But why should that mean that no one should be able to have that choice? A lawyer's main job is to represent their clients in the best way possible. When you have a lawyer that you didn't choose and don't pay yourself, the likelihood of being unsatisfied with their work is a lot higher. We have a clash of interest here. The lawyer is working primarily for the state and not the client. So the interest of the state will be their primary interest and not you. Government wants to establish a more fair system, but let's look at the main reason why the system is unfair. It's not because not everyone has the same kind of lawyer. It's because some people, it's because the state does not employ enough lawyers to represent those who have no choice, which leads to a workload and a less quality of defending a case. We need to fix the system overall instead of taking the approach of lowering the quality of the service for everyone. Because as I explained previously, there is no doubt that the quality will be there's no doubt that the quality will be affected badly. We know that public defenders are very important for the poor people. We're not saying we don't want public defenders. We're saying that this approach that the motion takes will lead to a very bad outcome, worse than we have right now. We're saying that the government should take steps to encourage private defenders to have better quality, to be less or not to force them to take a lot of cases, to make a good living and to pay off the debt that law school left them with. And having the approach of putting everyone or forcing everyone who wants to defend criminals into being a state lawyer is a bad approach overall and does not serve the main cause, which is having a fair and a better judging system overall. And I'm proud to propose. Thank you.
I thank the member for the opposition, and I'm happy to call upon the government whip. Hear, hear.
Can you hear me?
Yes.
Perfect. Just a second. Well, let's go. First of all, the main premise of opposition case in these debates, it is that average level of quality of legal services on defendant side will decrease. My teammate, well, let's work with it. My teammate, first of all, give you some explanations why average level will increase. I will talk about them later in extension part, but let's have 8 reasons why changes is not significant. First of all, we say that we still can give you ability to challenge, to change your lawyer and to choose your lawyer at the first time, and thusly you can control your potentially racist or connected with FBI lawyer and change him if he do not work well. Second, we say that competition between lawyers, if people have choice between lawyers and we can give it to them, still exist. And why? Because there are still a lot of lawyers, even if they are not very experienced as oppositions try to tell us, this competition still give you incentives to become someone who will be chosen by defendant and who will give and these competitions make create incentives. Well, next point is that lawyers actually often have incentives of fame, of prestige, and we explained on extension speech why law students, junior lawyers, even experienced lawyer have this motivation as primer, not the money. Moreover, we say that lawyer professional associations still exist and they are comprised of lawyers. Those lawyers want a lawyer profession to be still trustworthy and prestige for their own incentives of those lawyers in association. Thusly, they have significant incentives to bear from legal professions a lawyer who is compromised by who is stained by connections with government, who is stained by racism or bad performance on their work, and it's also give incentives even bad lawyers to work well. Next point is that there still exists negligence sues to lawyers. It means that lawyers, if he do not perform well, can be held liable for bad performance. And the problem is that moral harm which he will be obligated to compensate is so significant that it very often exceeds all assets of those lawyers, and thusly those probability of negligence sue create huge incentives to still work well, disregarding your experience. Sixth point. Premise of closing opposition that law school makes you take loan is first, doesn't work if you have paid your loan, and thusly you can change your profession after full payment. And second of all, it's not true in case of instance budgetary education, which very often exists. For instance, it can be also case of grants. It can be a case of even private philanthropists who gives money to, for instance, poor students, and they don't need to pay those money back, and thus the problem do not exist. Moreover, we say that if this is a case in debates about developed countries, we believe that people there don't have money very often as primary motivation to choose potential profession. Just because there are not so significant problem with money, you in all cases will have enough money to live not so bad. Moreover, we say that, and this is very important, at the status quo accusation party, government attorneys in the proceedings are public, and thus they are also under all conditions given to us by opposition about incompetence, about about the fact of about the experience and skills, and thusly balance between accusation and defense in this case will not be touched very in extreme level. What we say in our extension, first of all, about opening government, we explain why average qualification of lawyers exist, and thusly what is principal difference between us and opening government. Opening governments, all they tell us is literally people like criminal law, and thus they will stay or choose criminal law. We explain why this is true. We say that it gives you feeling of your own, of your importance for you and for other people, because you not just save money for rich bastards, but you preserve very important freedom of choice and all that romantic stuff of opening position for people, and thusly those incentives very often prevail over money. Moreover, we say that opening position says we can't find money. Opening government do not explain how we can find it. Well, opening position do not explain why we cannot change budget priorities and, for instance, take some money from, I don't know, war budget and don't give a damn about those bastards. Moreover, we say that private lawyers, even if we agree that they will not exist, have serious incentives to fraud defendants, have serious incentives to unethical conduct, to fraud about abilities of those lawyers because of huge contingent on success fee and financial, not ethical, self-realization incentives. And thusly, moreover, they do not want to take hard cases, and that is why a lot of people, poor people, middle class, or anyone else, do not get significant defendant in their life, and thusly we are very proud to propose. Thanks a lot.
I thank the government whip, and I'm happy to call upon the opposition whip. Hear, hear.
All right, so to sum up this debate so far, we would sum up basically the opening half of this debate as the OG, like talking about the benefits of having a defense state employed lawyers and why they are good for the economy, why they are good for the low socio-economic status. We could not afford private good lawyers. And we have the opening opposition talking about the downsides of not being able to pick your lawyer and why is this a bad problem. Now, we believe both arguments and both sides have some validity to them, but we believe that they are somehow off clash. Why? Because the main clash of this debate is going to be having all defense lawyers being appointed by the state and actually removing the whole private sector for defense lawyers. Now, we have to understand one important concept is that this practice is like a subspecialty of lawyering. We have divorce lawyers, we have prosecutions lawyers, we have defense lawyers. So basically, it's somehow some sort of a subspecialty of being a lawyer. So having this understood, we would like to discuss what the opening government said and say why it's very problematic, the kind of rule that they pass. So, first of all, they say that they limit the impact of difference in socio-economic status for the defense part of the court. Now, this, well, on the outside would sound like, okay, we're decreasing some inequality in the world, while this is like only on the surface, but if we like look into the matter more deeply, we will understand the court has two sides. We have the prosecutions and we have the defense. We are limiting the socio-economical effect only on from being upon the defense, and we are limiting it on the prosecution's part. Now, this is a problem because this creates more unfairness, as equal unfairness is less unfair than we have separated unfairness. For example, when we see a community having low access to opportunities of jobs and education, well, that's a bad thing. This is unfair because their socioeconomic status. But when we think about women in this society having even less access because of some kind of difference between them and men, this is more unfairness, and this actually applies to this case, the OG case, having said that the socio-economical impact would only be limited to prosecution. Now, this is why we think this is kind of unfair and increase the unjust in courts. Now, okay.
Point.
Now, for the closing government, their case has like revolved around one important premise is their case was very similar to the opening government, but they added one thing, that there going to be some kind of a success incentives. Now, we believe this concept is very problematic because, first of all, people should not be paid for practice like lawyers if they won the case. This creates a very hostile, toxic atmosphere. It's like it's similar to paying a doctor less money if their patient dies while they did all their best. This would lead to two problems regarding courts and judging. First of all, lawyers will only take easy cases if they have the choice, which they don't, but they will actually might refuse some cases and like would be able to drift towards easier cases. And if they were assigned some hard cases, they would work less on them and they would give them less attention in comparison to easier cases they're assigned to. So this would lead more unfairness, as they would be working less on hard cases because they wouldn't be able to get paid from winning these cases because they're hard, and we will focus on easier cases, which will create further injustice in the defense part. No, thank you. Now, these two factors would lead to more stress on lawyers on the defense. Now, in the closing opposition side, we added a new stakeholders, which are very important to our case, and further explained why the injustice would not be solved, it's maybe further increased. Now, the new stakeholders my partner added are the lawyers themselves. We had two main arguments and two main cases. The first one is economic, the second one is the lawyers themselves. Yeah, what's your point?
Look, there are two cases. First one, when poor is accused. In this case, we will give him the best lawyer. When poor is accuser, now the rich person will get the equal lawyer, and he couldn't be able to get the best lawyer he's possible.
All right, thank you.
So that's why it is an equal way to get this.
Thank you. But what if the prosecutors was rich and he couldn't appoint the best lawyer, while the defense had a mediocre lawyer, and the case was won because the prosecution had the money and to be able to appoint the best lawyer in the country and win the case? Well, it was unfair and was just like unjust case for the defense. This is more injustice than having these two sides playing the same game. So my first is the economical problem. Now, this would reduce the quality of practices of defense lawyering. Now, this is mainly due to two reasons. First of all, there's going to be no incentives for working harder. There's going to be, as I replied to the closing government case. And second of all, the student loans is a huge problem for them. Now, the closing government web said that this does not apply if the student had paid their loans. Well, most of students don't. This is pure statistic. The student loans in America is a huge problem that every U.S. President candidate talks about and try to solve. It's a huge problem there, and it's crippling. And people going to, for example, Ivy League colleges and university will be burdened hugely by these loans. Now, adding these two components together, no thank you, I'm not taking POIs, would lead to less growth for these lawyers as they will be less motivated. This is basically the capitalist versus communist kind of update on the community as competitivity versus equality in general. And we believe in this kind of sector, having the let's say the communist part or the communist point of view is harming for the side of the defense because we only limited to a subspecialty. Now, this would lead actually to lawyers running away and changing specialty. They say that we're going to force more lawyers into this field, but they're going to change this field because they can not work this field. They can be like divorce lawyers and all, and this will further weaken this part. The second argument that my partner said is they will not be able to pick their cases. Now, this is lead to two main problems. The mental health issue. We as debaters, when we debate something we believe against, we have huge time debating this subject. Now, what if this subject actually had consequences? We're just debating ideas. What if this led to a problem? Now, having this, for example, a feminist would be forced to defend a rapist because she couldn't pick their case as a state-owned lawyer. Now, this would lead to huge mental health problems for these lawyers. This would lead them to work less effectively. Now, for the opposition versus the government worlds, we compare that the opposition world would keep things as they are, maintaining all the benefits of having defense lawyers that are government appointed because as they are providing more access to poor people while not having all the downsides of increasing injustice between the courts, between the prosecutions and the defense, and the amount of pressure and the amount of economical and mental pressure applied upon these lawyers from having to work for cheaper money, being drowned in debt and student loans, and having to be deprived of. Okay, thank you. For this, I would like a pause. Thank you.
I think the opposition whip those triggers the debate. Let's take 2 or 3 minutes of break, and then we'll do the call and the rationale. So I'm going to do things a bit differently now. Honestly, I think a lot of the calls in this debate are quite close. I'm going to give you a call, but I'm going to go one by one on the teams and make all 6 comparisons, or at least more than 3 comparisons, in order to explain how this debate develops and what are the question marks that still remain open, at least to me. My current tendency, and this is a very light one, is to place opening government first, closing opposition second, opening opposition third, and closing government fourth. But I honestly think that almost any permutation of any change or any switch, or any swap in that call is legitimate and reasonable. Let's go one by one. Let's start with the opening half of the debate, explain what happens there, then we'll bring in CG and then CO. So let's start in the opening half of the debate. So two things that are important to understand before we even, actually no, let's just dive right in. So basically opening governments say two things. Firstly, poor people now don't have enough access to rich lawyers. Only rich people have access to good lawyers. Only rich people have access to private good lawyers. It seems unfair that the randomness of whether you were born with or without money, or the randomness of wealth, will determine the consequence of a trial. This is their intuition. I think it's somewhat intuitive. Secondly, they mitigate some of opening up opposition's case, though not opening up's case. Rich people would still have access to okay lawyers because a lot of them are going to move to be employed by the state. Not a lot of analysis there, but they tell us two things on why lawyers are still going to practice criminal law. First, because they still want that social and professional recognition. And secondly, because a lot of people just like doing criminal law. Opening up say a couple of things in response to that. Firstly, they tell us, look, people have a freedom of choice. And more clearly in the second speech, they tell us, somewhat similarly to home security systems, the fact that you get a worse off situation doesn't mean that it's okay to ban it altogether. And then give us another intuition of this might be a life and death situation. We're going to address that more directly when comparing opening up to opening up in a second. Secondly, they tell us that there is still inequality because the accuser can still use a private lawyer, even though the defendant can't. Sadly, I'll have to disregard this point. Honestly, it is just factually incorrect. CG pointed out and they are correct, but regardless of that, we're talking about criminal cases. I think it is reasonable to know, or at least reasonable that most people know, that the state is the one that sues and therefore uses public lawyers as well. And therefore, I think that the entire point of, wait, but what if rich people now sue poor people and they can use private lawyers? I honestly, it's just not in the debate. It doesn't exist in real life as I know it. I will address that, however, even if it exists and even if it's a legitimate point. And then thirdly, they tell us there's going to be two possible issues. The first one, the lawyer might be racist. And second one, if I don't choose the lawyer, I'm not going to be able to trust them and therefore not going to be able to tell them the entire truth. And therefore, worse outcomes. Firstly, I think that opening government engage well with the last point from opening up. I completely accept the response, at least that says, A, we can regulate lawyers and don't hire those that are racist, and B, and more importantly, given that I don't know how many of these lawyers are so racist, regarding the point of trust, it seems to us, opening government say, it seems that they have a large incentive to tell the lawyer the truth because that would keep them out of jail, and opening up never responds to that response. So I think it is, maybe we're going to have some racist lawyers, maybe 1 in 100 people. 100 people is not going to trust their lawyers. I don't think this is likely to be a large enough issue to beat the benefits from opening government of more people getting better counseling. Then let's discuss the question of whether it is justified or not. So I think my main issue here is that it's just competing intuitions. And I honestly think that at this point of the debate, opening government's intuition is slightly stronger. Opening governments say from the get-go, it seems unfair that one person would go to jail because they're poor and the other won't because they're rich. Opening opposition never engage with that idea and only tell us it's not okay to do so because it is, quote, life or death, and the analogy to home security systems. I think there are two reasons why I find these unpersuasive. Firstly, regarding the idea of life or death, that seems true under both sides of the house. Also, poor people might spend most of their lives in jail if they get convicted. It's unclear to me why the fact that it is life or death means that we don't care about whether or not people get convicted because of random reasons. Secondly, I think that the home security system is a nice analogy, but again, I'm not sure I'm that much against it. If you would have told me that a lot more, like less people would die, and if we um, redistribute now the defense systems across society. So at the end of the top half of the debate, I think that most of the harmful consequences by opening opposition are very unlikely, given their analysis and the responses they get from the opening government. I think that opening government managed to prove slightly better that we have the right to do so, and it is something that is okay to do, and the consequences are going to be largely okay. And even if I accepted the point from opening up about the accuser can still use the private lawyer even though it's a criminal case, I don't think that it proves that the system gets less equal. I think that in some scenarios we keep some of the inequality. I don't think this means that we get a less equal system overall. So I think at the end of the top half of the debate, I'm quite convinced that we get a more equal system. That is a beneficial thing morally, and that we're unlikely to see any dire consequences or even mainly negative consequences, and therefore tend to place opening gov above the opening opposition. Let's bring in closing gov. So closing gov say three things, or four things that I think they should be credited for in regarding the top half of the debate before we even bring in CO. Firstly, closing gov tells something about another rationale of why having a public lawyer might screw poor people because they are then compared to the private lawyers, etc. I don't think this is an important point in the debate. I don't think anyone disagreed that on average public defenders are worse off than private ones. I don't think OO contests that. I think that OG already analyzed it to enough of an extent. I don't think that is an important contribution from CG. I don't think it's clear why it is on clash in the debate. Secondly, it tells there are still enough reasons for lawyers to want to stay in the system. Firstly, because it is important, life or death situations, as opening up say, and some lawyers want to work on their hard cases. Those are highly publicized cases in some extenses, and maybe it's slightly more stable than being a private attorney. I think that the third reason is not convincing, given that if that is the case, then those people would have been public lawyers anyway. It doesn't explain why people would stay. People who went to the private practice would stay in the would be willing to shift to the public practice. But I think that the other ones are some sort of an extension above the opening government. Thirdly, closing government tell us that private lawyers are able to extort their poor defendants because it is a life or death situation. People are irrational. The last contribution that CG get credit for that is relevant to the top half of the debate is that I think that they give very good responses to OO's case on bad lawyers. They tell us how there's still competition, there's still prestige and publicity. You can still sue them for negligence, and you can just mechanistically allow those people to choose their lawyers. And I think those responses are better than OG's responses. There are two issues at this point of the debate with closing government that makes it difficult for me to place them above opening government specifically, and even in comparison to the opening opposition. First one, comparing them to the opening government. Closing government never actually explain why their contributions are more important. They do have some addition on why we're going to still have lawyers in the system. However, there are two things that are true. A, they never weigh that against anything that the opening government says. B, and this is also going to be important when comparing them to the opening opposition. Note that closing government's responses to opening opposition and how there are enough incentives and reasons for lawyers not to behave in a malice way is also true for closing government's point about extorting poor clients. If I think that it is very unlikely for lawyers to do a bad job because they are competitive and care about publicity and they can be sued for negligence, all of that seems also true for extorting their clients, their poor clients. So I think that closing government's responses to opening up also mitigate closing government's case. Therefore, I need to weigh closing government's case the following way. They have some extension on why we're still going to have good lawyers in the system. They have good responses to the opening opposition case about at least about the practical harms. I have no idea why, given that A, they should beat the opening government have sufficient responses to the opening opposition, opening government have similar cases about people staying in the system even though slightly less analyzed, and opening government also gives me a principled intuition or case. Closing government never explained to me why they should beat the opening government. Secondly, even in comparison to the opening opposition tell government teams, look, given that it is a life or death situation, people have the right to get a private lawyer, even if it means inequality, just like we allow people to have home security systems, even though poor people might not be able to afford them and therefore get more harmed. I don't think, unlike opening government, who had less of a chance to engage with that idea and had a principled case of their own, closing government never respond to that point. So even if I accept that we're going to have good lawyers, even if I accept that we're unlikely to see malice behavior of those public defendants, I am unclear why do we have the right to disallow these people to use private defenders, why it is okay for us to only allow them to use public defenders and not allow them to protect their own lives with the best attorney they can get. Given all of those issues, I find it hard to place closing government above both opening teams, even though I think that analytically speaking, closing government do a better job in certain areas analyzing and responding to the other teams. However, strategically, they don't analyze in the places that are most important, and they don't respond to the crucial cases brought by either opening opposition or weigh their contributions against the closed opening government. But again, I could see a call in which one of these comparisons or even both of them get switched. Let's bring in closing up. I think that closing up tell us three things. Firstly, that lawyers are now going to, given that they have a lower salary, they're going to have to take upon themselves more cases and therefore are going to have less time for each case and are going to do a worse off job. I would say, even before comparing that to the other teams in the debate, this point is very uncomparative. It seems that this is the case for public attorneys anyway. It is unclear why the end result for people who hire public attorneys is worse. Moreover, and this is on a more personal note, lawyers don't necessarily get paid per case. A lot of lawyers, specifically public attorneys, are paid on a monthly wage. Secondly, thus, given that law school is very expensive, lacking the high salary afterwards, some people would not go to law school, or even if they would go to law school, they still can go practice other forms of law, divorce, and other things like that, or what they probably mean commercial. And thirdly, I think that closing up don't actually analyze that, but they say something about the fact that maybe there's going to be some conflict of interest because you are both employed by the state and are supposed to be against the state and protect the defendant even when the state is suing. Let's start comparing them to the closing government. So I think that closing government are in direct clash, at least in one area, with the closing opposition. And I think that I tend to accept that a lot of lawyers would stay and some lawyers would go. It's unclear what the consequence is at this point of the debate of that, but I think that closing opposition are correct, that some people do care about money and can get into debt, at least the way this debate develops, and therefore are unlikely to stay as criminal lawyers after the motion passes, or in 10 years to still have the same amount of criminal lawyers. However, I do accept that there are still some incentives and people can still get grants in order to pay for them. So I accept that there is some percentage of the people that closing government are correct about and would stay criminal lawyers under the public system. I do accept closing opposition's extension that some lawyers care about money, need to pay student loans, and therefore would go practice other forms of law or wouldn't practice law at all. However, I do think that given the two other points from the closing opposition that closing government don't respond to, I think that I accept that overall we're going to have a system that is worse off. I think that there's going to be some conflict of interest, and I think there's going to be more of a burden on the public attorneys. And I think both of these prove at the end of the debate there's people are going to be worse overall to some extent. Comparing them to the opening opposition, I think that just closing opposition give us better analysis on almost each and every point, and therefore I tend to place them above the opening up. Comparing them to the opening government, I just think there's a problem of being comparative with the opening government. So specifically, A, the idea that it is unjust for some people to get out of jail because they are richer, and secondly, the fact that poor people specifically, even if some of the good lawyers now leave, get on average a better lawyer. I think that closing opposition never compare that to the opening government's case and never explain why that is more important. I tend to say that closing up is the position I am least confident about in this debate at this point. I honestly could see a call that also places closing opposition at the fourth place. I could see a judge giving them the first place in this debate. I honestly think that given the unclarity on engagement and some unclarity on to what extent closing opposition proved things, and that I didn't have the 15 minutes of panel to discuss this, my current intuition is to place them in second, but it could also be a third or a fourth or a first, given the trade-offs I've just listed. If I don't think they analyzed it this well, then closing government have just more of a contribution in the debate, given that they prove most of the lawyers would stay and therefore people would be better off, and given their responses to some of the material from the opening opposition, maybe these two contributions are more important than CO's case at that point of the debate. Given that CO don't weigh against their opening opposition, maybe that would be sufficient to place closing up below the opening up. My tendency is currently to say that what I said previously, the fact that closing government have little extension on the, I think that at the end of the bottom half of the debate, it's more likely for us to see a lot of lawyers leave and the lawyers remaining being swamped and maybe under conflict of interest to place closing up above the closing up, and that closing up just give more analysis than opening up to a significant enough extent for me to place them above the opening up. However, I am really uncertain about that part of the call. I know it was slightly maybe unclear, and if you have any questions, feel more than free to ask me right now. But I think it was worth the time going over all of the teams and making all of the comparisons specifically in this debate. So are there any questions about the call or the explanation from the call?
Everything is okay, but can we get like personal feedback?
Yeah, I'm going to do quick personal feedback if it's okay, because I have to go in like 13 minutes.
Yeah, no problem.
Cool. So opening up. I think that two things. I think that the main thing is they need just more analysis on each one of the points. Mainly on the point of the principle, why is it the case that we care more about equality than just overall, like the ability of people to protect themselves? This is obviously going to be a clash in the debate. You give me some intuition at the end of your speech about why that's the case, but I need actual analysis of when do we allow or when we don't allow people to use their wealth in order to promote themselves. I think there are intuitions to both ways, and I think it differs from country. Some countries allow for private health, some countries don't. Most countries don't allow, for example, for prisoners to pay for a better prison cell or something like that. But I need an actual analysis of why that is the case. Secondly, if you choose to analyze why a lot of lawyers would go to the public system, I think that is a correct choice to do to some extent. I would like actual analysis of why not only does is the system okay, but why does it get even maybe better to some extent? Why are we likely to see most of the good lawyers moving through the system? Why are we likely to see people still coming into the system in the long run, etc.? Deputy Prime Minister. Two main things. Firstly, I think that a lot of the responses are quite good. I do think, however, that I need a stronger response to the point about